Will contests are one of the most emotionally charged and complex challenges families can face during the estate process. They can delay the distribution of assets, drain resources, and create lasting divisions among family members. That's why understanding what causes a will to be contested and how to avoid those pitfalls is absolutely essential. A will contest occurs when someone with standing challenges the validity of a will. This can happen for many reasons, but the underlying concern is usually the same. Someone believes that the will doesn't reflect the true intentions of the person who created it. In Massachusetts, there are several grounds on which a will can be contested. One of the most common is the claim that the person who created the will, called the testator, lacked the capacity to do so. To make a valid will, the testator must understand the nature of the property, the people who are set to inherit, and how the decisions will affect the distribution of their estate. If someone believes that the testator didn't have this understanding, they may challenge the will. Another frequent cause of a will contest is undue influence. This happens when someone pressures or manipulates the testator into making decisions that don't align with their true wishes. It could be a family member, caretaker, or even a close friend exerting control over a vulnerable person. This type of contest often stems from complex family dynamics and can be really difficult to prove. Improper execution is another issue that can invalidate a will. In Massachusetts, a will must be signed in the presence of two disinterested witnesses. If this formality is not followed exactly, the will could be deemed invalid. Unfortunately, even a small procedural mistake can open the door to legal challenges in the future. Fraud or forgery is another ground for contesting the will, although it's less common. This might involve someone presenting a forged document or misleading the testator into signing something that they didn't fully understand. While it's less frequent, these claims can have serious consequences for the estate. A contested will can cause immense stress for families both financially and emotionally. It delays the distribution of assets and often pits family members against each other, creating rifts that may never heal. Avoiding this scenario should be a top priority for anyone who's creating or updating an estate plan. So how can you reduce the risk of a contest? Start by ensuring your will is executed properly. Work with an attorney to make sure that all the legal requirements are met and documented. Communicate your intentions clearly to your loved ones so that they understand the reasoning behind your decisions. Regularly review and update your will to reflect the changes in your life and relationships. And above all, avoid making handwritten changes to your original will after it's been signed. Even small, well-meaning edits can lead to confusion and disputes in the future. If you find yourself questioning the validity of a loved one's will, or if you've received an objection to a will that you're involved with, don't navigate this alone. Contact us to ensure your rights are protected and your loved one's wishes are honored. Avoiding a contest isn't just about preventing a legal battle, it's about preserving your family's relationships and legacy.